Hi, my name is YOGYA Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about grant of bail. What do you think happens when someone commits or is suspected of committing some criminal offense? The answer is that he or she gets arrested. However, they can apply for bail in this case, which is a remedy for a person to free him from legal custody. If the police are unable to find any strong evidence or the court is not able to prove that he is guilty, then the time he stayed in jail would be the violation of one of the most important fundamental rights, Article 21, which is right to life and personal liberty. It protects citizens when there is a threat to life and freedom. The time the suspect spent in jail until proven guilty becomes a violation of personal law. The Indian society looks down upon those people who get arrested, even when they are proven not guilty in front of the court. It affects the reputation of the family and destroys the career. Although they are granted bail due to the absence of any evidence against them, yet they are named criminals by the society. It is important that we do not deny any citizen their right to personal liberty, even if they are suspected to be a criminal. It was held in the case of Deepak Bajaj versus State of Maharashtra and another that the reputation of a person is a valuable asset with regard to Article 21 of the Indian Constitution. Thus, it is important to maintain a balance between the personal liberty of an accused person and the police investigation rights. Granting of bail is difficult that requires a detailed discussion of the evidence and an elaborate documentation of the acts of the accused. When the offense is of a serious nature, bail can be granted only after keeping in mind the seriousness of the offense, character of the evidence, detailed process, and the larger interest of the public. This article will discuss the condition and the consideration of granting bail. Condition imposed at the time of granting bail. Conditions at the time of the bail are described under Section 437 of the CRPC. The court cannot impose on the accused or a suspect any kind of irrelevant conditions or any condition that they know the accused cannot fulfill. Amendments are made under Section 437 subclause 3 which given the court the powers to impose a condition on the accused. They are: the court has to keep in mind the kind of allegation against the accused and then analyze whether the evidence is in favor of the accused or not. This means if the kind of accusation and evidence is serious, then the court has to consider the conditions which are imposed. During the time of bail, the person who is accused should not carry out any similar offense or crime which he is suspected of. The accused on bail should not influence the witness or tamper with evidence or talk about facts of the case that will affect the case. Genuineness is an important element of granting bail, and if there is doubt regarding the crime, is entitled to get the bail. In the case of Sumita Mehta versus State of NCT of Delhi, as the amount set by the High Court was very high and unreasonable, so the Honorable Supreme Court overruled the decision of the High Court of Delhi, where the bail applicant was directed to give 1 crore rupees in the fixed deposit in the name of the complainant in the bank to keep the fixed deposit receipt with the investigating officer. In the case of Sheikh Ayub versus State of MP, as in this case the Apex Court made a judgment that the High Court has a responsibility to consider all facts and circumstances before granting bail. As in this, the appellant granted the bail and the court said that the 2,50,000, but after that the court asked him to give 50,000 rupees as the surety, so that the appellant claimed that the 2,50,000 was not warranted as the part of the condition of granting bail. In the case of Ramathai and others versus Inspector of Police and another, the High Court of Punjab and Haryana set an amount of 32 lakhs which was unreasonable and a heavy amount, which the appellant did not have the ability to give this huge amount. So Apex Court said the High Court did not consider all the facts and circumstances properly, so the matter was given back to the High Court again. Considerations at the time of granting bail. When the court is granting bail, then the court should only consider the evidence of the witness which are appearing to be true, but in reality they may be false. The court should not investigate on the reliability of the evidence. This should be checked on the trial. The credibility of the witness is to be questioned at the time of the trial. If a person is accused of non-bailable crime or offense, then the main consideration would be taken as the nature or significance of the offense or crime. While in the case of granting bail, the Apex Court, in the case of State of Maharashtra versus Sitaram Popat Vital, has given some factors which should be considered before granting bail. That is, the nature of the allegation and the gravity of punishment in the case of alleged and the character of the supporting evidence, the sensible worry of tampering evidence or witness and giving threat to complainant. The court should be satisfied with the evidence and witness in the support of charge. Sometimes the court has to investigate some factors before granting of the bail. They are: there is or is not proper evidence and witness to be convinced that the accused has committed the offence that are charged against him, the character and the severity of the charges against him, if the applicant will be able to run away when he is released from the jail, the past record of the applicant, the possibility of doing the same offence when he's getting bail, the possibility of the evidence and witness being tampered, the opportunity of the applicant to get his defence on merit. Thank you.